Okay, who will be the defense's first witness for today? And Mr. Ashton, you indicated that there may be an issue with Dr. Rodriguez.
Yes. The first issue is the court had left the issue of a sanctions package as to this witness for later consideration. We did take his deposition from 1:45 to approximately 3:45 on Saturday. I just received a transcript of the deposition yesterday. I've read through it once. I would like to read through it again in preparation for cross-examination. So number one, I would ask that this witness not be called immediately, because obviously I need time to consider what he said. There is one particular area that he proposes to give an opinion that the court would need to review the transcript that I don't believe he is qualified to give. Specifically, just to summarize it quickly, he proposes to give an opinion that other people can't distinguish human decomposition from other odors. And to very briefly state it, after some considerable questioning, he finally came down to say essentially that it was just based on his personal experience rather than any studies or scientific literature. But I would like for this witness not to be called first, because obviously I need to have time to prepare for cross-examination from this lengthy deposition that we took and have a hearing on that one issue, which because of the violation of the discovery order, obviously I was not able to do. The one opinion I just mentioned is an opinion that was not contained in his original report. So it is new. There are other new opinions as well that I may be able to deal with on the fly, but I would just request that counsel not be permitted to call this witness until I've had at least half a day or at least some kind of break to digest the deposition and prepare for cross-examination because of the discovery violation. The other issue that I mentioned at counsel table is at sidebar, is as to a witness, Mr. Eichenblum. Just so the court has this, and I don't necessarily want to argue sanctions on this right now, but I just want the court to know it's coming. We received a half a page report from Dr. Eichenblum pursuant to the court's order that essentially contained no opinions or conclusions of any kind. Mr. Eichenblum showed up Friday outside and prompting us to question counsel about what he was here for, since his report indicated nothing, essentially. Yesterday, and Mr. Eichenblum showed up at my office yesterday afternoon for a potential deposition, but I sent him away because without a report, I have no way of deposing him. I received a report which is 2 pages in length and a 45-slide PowerPoint presentation yesterday from counsel. I'm providing the court with both. I am willing to depose Mr. Eichenblum Tuesday evening to do as much as I can. I will be preparing a sanctions package for the court because, again, this is, I believe, another deliberate violation of the court's order. May I approach?
You may. What is Dr. Eichenblum's field of expertise?
I think he has phrased it as DNA and trace evidence or crime scene evidence, something general in that sense. It's in the report. He is proposing to give a number of opinions on, I guess I should say, the interpretation of negative DNA evidence. But it's reflected in his report. Again, I'm not prepared to argue the issue now because obviously I haven't deposed him yet. I need to do that, and I will do that on Tuesday at 5:30, should the defense produce him. So those are my requests at this point, is that Dr. Rodriguez not be permitted to testify until I've had time to review and prepare for cross-examination because of the last-minute nature, and that Mr. Eichenblum be ordered to appear. I will be presenting the court with additional requests for sanctions to alleviate the prejudice, but at this point, those are my initial requests.
Under Rule 3.220, the prosecutor is afforded the right to take depositions in a case. This is a capital case for which he is prosecuting and seeking the ultimate penalty. The witnesses in question were listed timely and were ordered by this court to issue a report under time constraints. I immediately instructed each witness to put together something as quickly as possible, despite having the proper amount of time to ensure that every single opinion that they have that may come up during the course of trial, which is clearly an unscripted event, would allow them to put something together to completely comply with the court's order. The court's order under Section 4, Section 4, Paragraph 4 states, opinions not expressed in written report or, emphasis added, at deposition taken during discovery will not be permitted at trial. The prosecutor in this case has attempted to narrow the scope of the testimony of these expert witnesses by intentionally refusing to take their depositions. I say this is an intentional act because it is clear that there was a sufficient time period for Mr. Ashton to coordinate these witnesses for depositions, set them, and conduct them. This package that he claims to put together or want to put together can easily be done for him, as the state has violated this order itself on 2 occasions. One with Dr. Rickenbach, which was taken at sidebar. The objection was sustained because he wanted to elicit testimony outside of his reports or deposition, and it was quickly moved on with no threats of any sanctions and no threats of being held in contempt of court. Furthermore, when the FBI, with the late disclosure of photographs on the morning of trial, that too was addressed and moved on. I think that the court has made it clear that this is not a game, and that gamesmanship has been exercised by both sides. And I think that this is nothing but a clear exercise of gamesmanship that is carried on from Mr. Ashton from the very beginning. He is a skilled and experienced prosecutor that knows that with expert witnesses, you should take their deposition. I would venture a guess to say that he has never had a trial where he has just completely ignored expert depositions, especially those such as important as these. But yet he was armed with a court order which he thought he could play games with and use as a sword and both as a shield by completely and intentionally ignoring his responsibilities as a prosecutor to go forward and fail to not take a deposition. As it pertains to Dr. Rodriguez, the remedy under the law is to give the prosecutor time to take his deposition. These things occur on many occasions, and these are really minor issues. The duct tape opinion that Dr. Rodriguez is simply going to express is that there's no scientific basis to render an opinion as to where a piece of duct tape is when it is on a surface deposit site, because there are too many things that can alter the location of this duct tape. This is, aside from being common sense, this is being testified by someone who has the experience to do so. As it pertains to Mr. Eichenboom, we have attempted to, because of the failure of taking his deposition and what he might be able to testify to, one of the issues that we originally wished for him to testify about is the aspects of DNA. Low copy number DNA, degradation of DNA, all of which was given notice to the state, not only through my response in the pleadings to the court, but this is a common issue that the state is on notice of. Their claims that, and their potential arguments that the reason there's no DNA on these items is because of the elements, knowing full well that that could degrade certain DNA, but there still should be DNA on these items, and one can obviously and potentially testify to that. Some of the opinions that, some of the issues that came up with this case have come up recently, and I because not too many arguments were laid forth as it relates to Mr. Eichenboom, I'll keep my comments to a minimum. Mr. Eichenboom, as I expressed in open court Saturday, that we will be taking our that we will be wishing to exercise all of our depositions for any potential experts where the state has failed to do so. I asked and instructed Mr. Eichenboom to show up to the state attorney's office on Saturday afternoon, of which he did, and he was turned away. Specifically by Mr. Ashton, not by an associate, not by a secretary. Mr. Ashton told him to go away. Upon doing that, I instructed Mr. Eichenboom to prepare a report and to ensure and to do it immediately, of which he did. It was sent to me, and I forwarded it on to Mr. Ashton on Saturday evening, as well as any potential demonstrative aids for which he may find useful in explaining his testimony. That was also disclosed and turned over to him immediately. All of this is stuff, and all of this is information that just merely explains DNA and its processes, and that most of which I'm certain that Mr. Ashton, with his experience, would certainly be aware of and would need very little preparation in light of. Now, I think, as to Mr. Ashton's argument about wanting extra time to now review depositions, well, that's not a very good argument, considering the fact that for several months, approximately 7 or 8 months, he sat and decided not to take a deposition and not to prepare for this trial as needed. So because of his intentional omission, he now wants to delay this process. He wants to delay our time, the court's time, the jury's time, for something for which is his professional responsibility to carry out. The order, while the order is fairly clear, and I read this order to include 2 aspects of the discovery process. One, which is written reports, and the other which is deposition. The goal of this court was to prevent any gotchas. I specifically noticed that Mr. Ashton was intentionally omitting, or may omit, I should say, to prevent himself from taking these depositions, and I brought it up at a status hearing, and I warned the court that this may be an issue later on because the state is attempting to use this both as a sword and a shield. We did not intentionally look at this order and say we're going to disobey it. Just the mere thought of that disturbs me greatly. And it disturbs me that anyone would either A, make the accusation, or B, even assume it to be true. And I say that because I have labored on this cause daily, nightly, and it was made clear by the court to me that this court intended on issuing orders and enforcing them if need be. I see that even though the rules of discovery and the law does not compel us to ask experts to issue reports, this court ordered that. However, I think it is a severe and due process violation to try and limit our testimony, limit our presentation of case, because a prosecutor decides on his own, without assistance or acknowledgement from the court, to omit his professional responsibility and to omit his duty to carry out and utilize those tools which are afforded to him under the rules of discovery, and then attempt to use that as some form of sanction. Okay, it's not bad enough that he wants to omit these responsibilities in the efforts of taking a human life. He wants to go after her lawyer too. And I think it is repulsive, and I think it is also not under the law, and shouldn't be dignified in any way, shape, or form by this court. He had a responsibility. He intentionally omitted that and neglected it, and he should not be allowed to come forth, not even at the 11th hour, at the strike of 12, and decide, okay, now I want to utilize something, and do it in a manner that is, I don't want to use the word disingenuous, but to do it in a manner where it's unreasonable. It's unreasonable that he should think that Dr. Rodriguez would have opinions such as these. These are obvious opinions. These are obvious things that, these are obvious troubles with their case, and they know it. Thank you, sir. Unless the court has any questions, I have no further argument.
Nope. Okay. I'm going to ask both sides to turn around and look at that clock back there and tell me what time it is. Mr. Ashton?
9:25.
And Mr. Baez?
9:26 is usually we don't agree.
Okay. All right. Thank you. That shows that the two of you will never agree on anything and will never interpret anything the same way. That jury has been sitting back there for more than 25 minutes. Sergeant, what time did the jury arrive here this morning?
Been there for an hour, sir.
Okay. Henceforth and forevermore, all the attorneys are required to be here exactly at 8:30. So if you have any matters you need to take up, you will notify the court deputy. The court deputy will call me and we will take those up at that time. At 9 o'clock, we will start. And no more will we have this. This coming Saturday, we will work a full day. So be prepared to have witnesses here to work a full day this coming Saturday. The rules of criminal procedure lays out what is discoverable, but it does not take away from the power of the court to order additional discovery, restrict discovery, or set whatever timelines this court feels is necessary. I will call your attention to an order entitled Order Granting State's Motion for Clarification or to Compel Compliance with Order for Additional Discovery, which is dated December 10th, 2010. I'm not going to go into the history of why this particular order was issued, but this is the pertinent portions of that particular order. Where the experts have not prepared reports of examination of tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in forms of written pleadings. The expert's curriculum vitae or qualifications of the expert. The expert's field of expertise or medical certainty. A statement of the specific subjects upon which the expert would testify and offer opinions. The substance of the facts to which the expert is expected to testify, and a summary of the expert's opinion and grounds for each opinions. That was done because there were a couple of reports that basically contain nothing. The court thought that order cleared up the situation. Here we go again. On January 6, 2011, the court entered another order granting state's motion for sanctions and motion to compel. Again, there was some lack of understanding of what the court may have meant. A statement of the specific subjects upon which the expert would testify and offer opinions, the substance of the facts to which the expert is expected to testify, and a summary of the expert's opinions and the grounds for each opinions. Court gave out an example of what was submitted on behalf of Dr. Henry Lee. Court goes on in its order and says that the defense shall provide written reports to the state from all expert witnesses, which shall include the following information: a complete statement of opinions the witness will express, and the reason for those opinions, and any data or any information considered by the witness informing their opinions or conclusions. The court in those two orders required both the state and the defense to have expert witnesses list all opinions that they would give. The purpose of depositions are to expound upon those opinions, and as all lawyers know, there is an opportunity for sub-opinions once someone gives a main opinion that they may want to discuss. It has never been the intent by depositions to alleviate the responsibility, and that was not the intent of this court's order, to say, well, you could either take their depositions or the report. The orders are quite clear to me. This court does not make threats. This court simply applies the rules. When the state of Florida had an exhibit that they wanted to introduce, i.e. a demonstrative exhibit that was not given to the defense, that exhibit was excluded and the state was not allowed to utilize that exhibit. The court on Saturday indicated that it was put in a proverbial corner, not being able to exclude these opinions by the defense. If you read all of the cases dealing with exclusion of evidence, particularly Dumas, Wright, Lott, Odom, and U.S. versus Hobbs, it frowns upon that because you punish the defendant. But what the Florida Supreme Court did not close the door on, if someone continues to repeatedly violate orders of the court, it leaves the door open, regardless of those severe due process considerations, that as the final ultimate sanction. There's never been a case where that final ultimate sanction has been imposed and upheld by a court that I know of. But one would surmise that if someone continuously violates a court order with impunity, whether or not the court would be left powerless or whether or not the Supreme Court will say, this is the case, despite the due process implications, where the ultimate sanction of exclusion would be proper. Yes, there have been gamesmanship in this particular case, and it is quite evident that there is a friction between attorneys. That is something that I guess the Florida bar will deal with. And at the conclusion of this trial, this court will deal with violations which may or may not have occurred. But it is not proper for the court to deal with it now during the pendency of this very serious litigation. As to the request of the state to defer the testimony of Dr. Rodriguez, I will grant that request. Now, I've announced to both the state and the defense that we're going to have a short day on Wednesday. And that's because of me. And I've explained to the lawyers the reason behind it. Let me say this to both sides. If I was the state or the defense, I would make sure when we recess this afternoon that I would go through the reports of all my experts and make sure that their opinions were contained in the reports or depositions. As I explained to both sides, sub-opinions, as long as it's under that general area on minor things, those are going to come up I've been recross or direct. You can't anticipate everything, but enough is enough. And both sides need to be forewarned that exclusion, even at the price of having to do it all over again, which I don't think I will have to do it all over again because of repeated violations. Exclusion may be the proper remedy if it continues. So, who will be the defense's first witness?
Judge, our second witness that we had intended on calling was Richard Eichenboom. But if, in light of that, we have to wait. We're in the process of picking up the third witness. It would take approximately 30 minutes to have her here.
Okay. Inform the jury that, and take them out since they've been locked up in that room for quite some time, that we will proceed at 10:25. Okay? The only thing I'm going to say is this, folks. I'm getting very, very close to starting this proceeding every morning at 8:30. And I know that would bring some problems. But at the same time, I've been trying to be accommodating with the work schedule for everyone. But I have a sequestered jury who live under severe restrictions. And if y'all don't want to act professional, then I will work you real full days. And that will include reducing your lunch hours. And I try to give you an hour and a half because I realize you want to eat, relax, and sort of look over your notes. But all of this, folks, is going to stop, or you will be working some very fierce days. So be prepared Saturday to go the whole day. Okay, we're in recess to 10:25. Okay, you may be seated. Okay, let the record reflect that the defendant is present, along with counsel for the defendant, Assistant State Attorney. Upon joint stipulation between the state and the defense, we will be in recess until 9 a.m. tomorrow morning. Is that agreeable with the state?
Yes, Your Honor.
And is that agreeable with the defense? Okay, We're in recess.